to Justice for the Serlick Children podcast.
We are not attorneys. Nothing in this episode should be taken as legal advice. The information we are sharing is based on publicly available records, court filings, and our own personal experiences and research. This podcast is for educational and advocacy purposes only. If you are facing a legal situation or have questions about your own case, we strongly encourage you to consult with a qualified attorney who is licensed to practice law in your state. Again, we are not offering legal advice, we are not practicing law, and the content is not a substitute for professional legal counsel.
Good evening, everyone. Today is Monday, March 9th, 2026. Welcome to Season 2, Episode 6 of Justice for the Serlick Children podcast. Tonight, we are going to discuss the recent disturbing activity with Florida District 5 Court of Appeals in Daytona Beach, Florida, as they continue to trample on my U.S. and Florida constitutional rights. Mark Ludwig's D.C. Title 4D Reform Advocacy and new book, plus Kentucky attorneys Christine Miller and Hugh Barrow's new Judgy app that launches on Apple Play Store and Google Store on Friday, March 13th, 2026.
Yeah, and as far as the 5th District Court of Appeals go, it has been sort of mind-numbing, from an outside non-lawyer perspective. They have really just laid it out there to make anybody question whether they do their job at all. So a quick timeline, and we'll get into the details, but almost 3 weeks ago, you got a notice from them. And just to remind anybody and catch anybody up to speed, you had 4 pending appellate cases in the Florida 5th District Court of Appeal. My
very first one was started in April of 2025, so almost an entire year ago.
And about 3 weeks ago, you got an order from them. They consolidated all 4 cases, which is a little ironic because you had actually asked for 2 of them to be consolidated originally, and then they denied you on that. But
it's in the docket. They literally denied my request for consolidation a while ago, and then all of a sudden,
and then they turn around and consolidate things. Yep. So that was about 3 weeks ago.
Yep.
Last Thursday, you get an order affirming the lower court's rulings with no findings, no opinion at all, nothing written or otherwise.
So this consolidation in question was February 19th. So just short of 3 weeks ago. What did I tell you they were about to do? What did I predict they were going to do?
Exactly what they did, that they were going to consolidate them and then just
affirm them and close them all out. I knew that was the moment I got this order. I literally said it out loud instantly. They are about to affirm all 4 of them and then close all of it out. Sure enough.
But then they went and did something else extra sketchy. 24 hours after they affirm them, they send you an order to show cause that you have 30 days to respond to because they're trying to put in place what's called a Spencer sanction.
Well, hang on. So for everyone listening and watching, I want you to pay attention to these 3 dates because these dates are very important because this is way too coincidental for this to be any sort of accident. This was absolutely planned, and they are trying to silence me. So, first appeal, 5D 2025-1056 was my very first appeal of Sandra C. Upchurch in the Daytona courthouse. And that was April of 2025. And then there's been some consecutive orders that she instantaneously denied since then. And so every time I would turn around and file a notice of appeal, I literally had
As is your right.
Yeah, it is my legal federal and state right to appeal things.
And some of what you appeal, just to make it clear, there is a process. So some of the orders, depending on what it is, you actually have to file a motion to vacate with the lower court first, And then if that gets denied, then the next step is to appeal to the appellate court. So
Right.
you followed the procedure.
Yeah, I did
exactly.
I did exactly what I was supposed to do. And so ultimately, it ended up with 4 total appeals. 2 of them, District 5 Court of Appeals consolidated almost instantly, and that was 1056 and 1442. 1442 was Sandra C. Upchurch denying her own motion to disqualify, which should not be legal in any way. It should go to the chief law judge, which is Leah Case, and then Leah Case should be reviewing the motion for disqualification and making a determination. No one should ever be in charge of reviewing their own disqualification.
No, and on that one, the reason she denied the disqualification, it was on a technical reason, claiming you didn't meet statutory regulation, but you actually did.
Yeah. So regardless, that case doesn't matter. She's gone from Daytona. She hasn't been on my case since September. I've had a new judge in Daytona since September of 2025. I have not, as of today's date, which is March 9th, I have not filed anything in front of this new judge yet. And the reason for that is because I have had a court case going on in Illinois Circuit 19 where all of this chaos began in 2020. I filed into Illinois Circuit 19 in July of 2025 since Florida is literally saying we don't have jurisdiction to deal with that 3-page order. I went directly to the source.
Yeah, and in legal terms, basically, even though you and Justin and the kids are all here in Florida, so for any future modifications, Florida court has jurisdiction, and technically they actually had jurisdiction when the Illinois court issued this order. But the Illinois court, any court that issues an order still retains original jurisdiction to modify or correct that order.
Yeah. So I have not filed anything in front of this new judge yet. Remember that when we get to this document. So the dates that are key. February 19th is the date of consolidation. So I'm going to read this to you. And of course, as always, all of these documents will be scanned into one PDF and then provided as a Google Doc link. So if you are listening to this on a podcast, it's just audio and you're not watching the video, just click that link and you can literally not only open, but save, download, save, do whatever you want with these documents. They are public record. They are my gift to the world. So Florida District 5 Court of Appeals in Daytona Beach, Florida, directly across the street from the Circuit 7 courthouse, mind you. Date February 19th, 2026. By order of the court, case numbers 5D2025 and 1056 and 5D2025 1442 have previously been consolidated by order of the court on June 10th, 2025. Ordered that cases 5D2025 2188 and 5D2025 2696 are hereby sua sponte consolidated with 5D2025 1056 and 1442, and that cases are assigned to the same panel for consideration. And all further filings should be made only on case number 5D2025 1056.
And just for a Latin update, that term sua sponte
means they're just doing it on their own.
Yeah, it's it's a Latin term that the courts use. For some reason, the courts still feel the need to use Latin.
Legalese. That's how they keep the layman out of court.
Yeah. Instead of just saying, we decided we're going to do this on our own.
So what judges are doing this? Let's talk about it. The panel of judges at this Florida District 5 Court of Appeals.
3 judges.
It's in Daytona Beach, Florida. The panel of 3 judges are, and I'm probably going to say this name wrong. I don't care because you're trampling all over my constitutional rights, so I don't care if I say your name wrong. Judge Adrian G. Soud, S-O-U-D. Judge Paige Kilbane. Judge John MacIver. And elected official clerk Sandra B. Williams. Okay, so these are the 4 players in Florida District 5 Court of Appeals that are walking all over my constitutional rights between Florida and U.S. and are contributing to hiding my children and abusing my children. So these 4 people are now going to get a federal lawsuit.
Now let's just slow down just a little bit. So they consolidated the cases. Now it's important to point out to everybody, all 4 of these cases were different orders that were being appealed.
And they were all different things.
From different dates. They were all for different reasons. And for the appellate court to consolidate them, that can be understandable because it is the same general set of facts for all 4. However, for them to just consolidate them and then say, just a short time later, the lower court didn't do anything wrong, and then 24 hours later send you the other thing they sent you, it really, really makes you, any normal person would look at the timeline and look at the documents. I mean, we've shared them before. These are not short documents. These are thousands of pages, by the way. Thousands of pages. In
total, the 3 orders that we're talking about with Florida District 5 Court of Appeals is 4 pages in total. This is an insult to me and every pro se litigant out there that works our ass off to actually research and do things that attorneys go to school and get a Juris Doctorate for, and we're doing it on our own. And this is all I get is 4 damn pages that takes them 5 seconds to type up.
Your briefs,
it's insulting.
Your briefs were like 50 to 70 pages long.
Yep. And they needed to be because I'm covering so much insanity that they're causing. They are causing all of this.
In addition to just the briefs that you file, there's an appendix. Those were like upwards of 500 to 700 pages.
Yeah.
And that's for each case.
Yeah.
So, I mean, really, it's really any layperson would say, you guys didn't read anything.
No, absolutely not. They did not even probably take a glance at it, let alone read it.
To allow the appellate courts, for them to have the ability to have a procedure where they don't even put out any sort of response saying, nope, this is wrong, this is why, this is wrong, this is wrong, this is wrong, this is wrong.
So that consolidation took place on February 19th. Then last Thursday, I get, like I predicted, I get a 1-page order from those said judges, Soud, Kilbane, MacIver, and it doesn't even have a signature on it. That's how much of a joke this is. It just says, on appeal from Circuit Court for Volusia County, Sandra C. Upchurch, Judge, Heather Louise Bendl, Edgewater, pro se, no appearance for appellee. They literally put on there that Justin Serlick never even filed an appeal.
Which is, it's not irrelevant. I mean, that's actually important too.
It's incredibly important. That means he's not even arguing anything I'm saying.
Well, and then it also, adds to the reasoning. How can the court, and we haven't really gotten to the Spencer sanction yet.
Can we get past this? Okay, so no appearance for appellee, March 5th, 2026, per curiam affirmed. Soud, Kilbane, MacIver, however you say his name, JJ, concur. That's it. That's all I got. No written opinion.
And why is it important to have a written opinion?
Written opinion is what allows you to appeal it to the state Supreme Court. So, if you don't have a written opinion, you can't move it to the higher court.
So basically, they're saying, we believe the lower court did everything just fine, and we're not going to tell you why your arguments were wrong, but we're also not going to give you any ability to appeal our decision for anybody to review what we did.
Yeah. So it was 1 page. The second page is literally, it's a generic thing that says not final until disposition of any timely and authorized motion under Florida our appellant P 9.330 or 9331.
Which
means
filed
that
the
15-day timer.
Yeah. So to respond to that, you filed yesterday a motion for written opinion and rehearing.
So that was March 5th. So March 6th, exactly 24 hours later, I get, by order of the court, Appellant Heather Louise Bendl continues to appeal orders denying successive and meritless post-conviction motions. Accordingly, it is ordered that appellant shall file with this court and show cause within 30 days of the date of this order why she should not be prohibited from filing any appeal, petition, pleading, or motion pertaining to the conviction and sentence rendered in Volusia Circuit Court Case Number 2023-01318828 FMCI, unless reviewed and signed by an attorney licensed to practice in the state of Florida. See State v. Spencer, 751 SO 2D 47 FLA 1999.
Now, there is so much wrong with this start.
Signed. So this one is actually signed. It was a stamp signature, but it has a signature on it, unlike this affirmed one that has nothing on it. So Sandra B. Williams, the clerk's signature on it, and then underneath, panel, judges Soud, Kilbane, and MacIver. And then CC to me and Justin Derek Serlick. So that's it. That is what they threw at me all within 2 weeks of each other.
Yeah.
Now tell me the timing of this is not grossly
well, not only that. So that motion,
February 19th, March 5th, and March 6th, all at once.
So let me explain something about this motion to show cause, because we had to look it up, and we looked up multiple sources, and everything sort of concurred and said, like, that court was basically so stupid that they put out something that they should be embarrassed about. So that the sanctions that they're trying to put out there, the Spencer sanctions, first of all, the language that they used in the order that they sent you was copied and pasted from a criminal form. Mm-hmm. Yours is a family law case, not a criminal case. Mm-hmm. The Spencer versus State of Florida case was originally a criminal case. So it applied to criminal cases. There was a subsequent civil case that allows Florida courts to impose these restrictions on civil cases. However, there are steps they're required to follow.
Yeah.
They are required to give you a warning if they feel you're filing repetitive, successive, frivolous.
And all of my filings are certainly not meritless.
No.
When Justin Serlick, Mary Serlick, and Ira Serlick are 100% hiding my children from me in Daytona Beach, Florida,
even on
in the
technical,
same city both of these courthouses are in. So
even on a purely technical legal footing, the court has no ground to stand there and say everything Heather files has been meritless, when literally there's a motion that Heather filed to consolidate cases. The court denied it, and then the court went and consolidated the cases on their own after that.
Right. But what I'm saying is they're saying everything I have filed in Florida Circuit 7, just fighting to see and speak to my children, they're saying are meritless.
Now,
so Ariana, Tommy, Bianca, and Charlie, these judges say that I have no right to fight to see and speak to you. So whatever Justin, Mary, and Ira Serlick are telling you is a lie. Because I literally can provide all documentation. These filings are my love letters to my children. These are public record. They are there forever. My children will always be able to see them, view them, read them. If you don't understand legalese, you can simply run it through AI, and Adobe PDF will literally give you an AI overview summary now. So you do not need to be an attorney, a judge, or understand legalese to understand what these court filings are saying once you run it through AI. It breaks it down in layman's terms. So Ariana, Tommy, Bianca, and Charlie, whatever you are being told, my filings are literally fighting for you. And these judges are telling me I have no right to fight for my own children. But at the same time, I don't have a right to fight for my children. They are also stealing 60% of my teacher's salary. If my rights are terminated, 99.9% of the time, the parent that has the rights terminated also no longer owes child support because they are completely out of the child's life and not supporting the child. When you are paying child support, you are to be able to see and speak to your children. And in the state of Florida, there is 50-50 custody for a reason. Florida state statute 61.13 is presumptive 50-50 custody with the best interests of the children in mind. And I have had zero access to my kids for 4 years, 5 years now here in Florida.
This is really...
So how is that meritless?
Anybody who gets stuck in the family court system, and we know this happens anywhere in the country, or all over the country, but here in Florida, with Heather's case specifically, what should have happened... There was an order issued in Illinois. Everybody comes to Florida. That order reserved your rights. It reserved Justin and your rights to your oldest child.
Mm-hmm. So she was in legal limbo.
You get an attorney in Florida. Your attorney looks at your documents, your case, tells you what has to be done to get it opened up here in Florida. So you follow through all of those procedures. What should have happened is your attorney should have pointed it out to the court that this order from Illinois, by its own language, is a temporary order. So here in Florida, it was basically should have been an initial custody hearing is what should have happened. And then it'd be 50-50 based on Florida rules.
Well, and that is why Justin, Mary, and Ira Serlick don't want Florida to alter it because they are aware Florida is a 50-50 state. Unless one of the parents has a severe criminal background or is an active drug addict.
Which you're not.
Yada, 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 all those things. There is absolutely no reason why a Florida public school teacher that teaches over 170 students cannot see or speak to their own children. So Illinois is not 50-50, and that's why they want to keep that Illinois order the way it is. But what they don't understand is Illinois did not have subject matter jurisdiction to write that order in April 2022 to begin with, because surprise, surprise, I transferred my Illinois driver's license to the state of Florida February of 2022, and that means Illinois lost...
It wasn't just subject matter jurisdiction. They had no valid jurisdictional claim.
No, they couldn't do anything. They could no longer touch me in any way, shape, or form because I was no longer a legal Illinois resident.
As soon as that judge in Illinois, who, mind you, I mean, Heather's case is crazy, and I know other people have crazy cases out there too.
We all have identical cases.
But Heather, in your case in Illinois, the family court case, you had one judge throughout most of it. And then once the kids get sent to Florida, he basically walks away from the case. A brand new judge comes onto the case. You have one virtual Zoom hearing with her where you tell her you've moved to Florida. She then says, okay, well, you have to transfer the case to Florida. Mm-hmm. And then the very next hearing, after she's told you to transfer the case to Florida, she issues the order that has ruined the last 6 years of your children's lives and your life.
Yep.
And there's
tyrants in black robes. They don't care who they hurt as long as they get something out of it themselves.
One of the biggest problems with family court is it is a system set up to drag things along as slow as possible to allow every lawyer and judge and quasi judicial officer, GAL,
foster parents,
to make as much money as they possibly can.
FOCs.
And it is sick and disgusting.
Psychologists.
And here's my one of the biggest problems with family court. These cases drag on for so long. The judges complain they're overworked, yet the judges give parties absolutely no path forward.
Right.
Because the judges just get the law wrong and don't care. And it's become so blatantly obvious that this is happening all over the country.
So you transferred the case, but showed up to the Illinois hearing.
No.
Tom, it's a lot more complicated than that. You might want to go back and listen to some prior podcast episodes to get the full scoop. Illinois dumped my children down in Daytona in 2021, and my kids were in legal limbo all this time, and they still are.
The short version of the story is the judge so the case originated in Illinois. Everybody lived in Illinois. Justin moved to Florida. Kids get sent to Florida through suspicious circumstances.
That's an understatement.
The family court.
Illinois DCFS trafficked my children.
The family court judge, who comes in. That was the first hearing that particular judge came in on. Finds out everybody's in Florida. Tells Heather, okay, go ahead and transfer your case to Florida. And then immediately after that, the next hearing that occurred ex parte, meaning Heather wasn't present, wasn't aware it was happening and what was going on with it. And the judge literally issued a de facto termination of parental rights by issuing an order that is so vague.
But hang on, you got to be careful with termination of rights. Well, they didn't terminate my rights.
Not a true
no,
TPR.
But people can hear that and think that my rights were terminated. No. They were not. No. This judge, Marnie Slavin of Illinois Circuit 19 in Waukegan, Illinois, reserved my rights to my children.
Which in legal terms just means a court is not deciding on this today. Some court has to decide on this down the road.
And it's been sitting in reserve status since 2022 when that judge did not even have jurisdiction to sign that because I was no longer an Illinois resident. Neither was Justin Serlick. So she should have not done anything moving forward. It should have been absolutely required to be transferred to the new home state of the children, which was Florida. So as of February 2022, Florida Circuit 7 had primary and sole jurisdiction over the 3 children that were down here for more than 6 months through UCCJEA, and Justin and I because we were both Florida residents. So this is how children are being hidden from their parents across the U.S. Yeah. These 2-3-page ex parte out of jurisdiction orders, which automatically make them by legal terms void ab initio. But good luck getting a judge to actually declare it void ab initio. Even though that's what legally is.
In Heather's case, once we became aware of the jurisdictional deficiencies in her case, and Heather tried to start raising them in court, your circuit court judge in Florida made a comment. Well, your time to challenge the jurisdiction
that was Sandra Upchurch trying to make me think.
Literally law school 101, first year law school.
Yeah, it doesn't see
void,
that's where you
there's
keep
no time limit.
That's where you keep giving them more credit than they deserve. She knew exactly what she was doing. She was literally telling me, yeah, I hear what you're saying, but F you, I'm not giving you your kids. I am your children's gatekeeper, and I work for the Serlicks. So that's why she's going to be sued by me in federal court. Anyways, so let's move on to my 2 responses. So I get the affirmed on Thursday of last week, and then Friday, that very next day, I get the, show cause that we shouldn't give you a restriction on filing and force you to pay into the RICO system.
So you basically turned everything around, worked on these through the weekend and got them filed. So these were the first thing they saw when they got
we worked on these on Sunday, got them filed Sunday night. They were accepted this morning. So these documents, we are not going to go through all of it because they are longer documents in this whopping 4 pages that they graced me with.
They're about 20 pages
Yeah,
each.
so we'll give you the overview, but these documents will be scanned with everything else to review in the Google Drive link. Again, if you think that any of my documents might give you ideas, concepts, a pathway, more power to you. I am providing these documents to everyone so you can maybe get ideas from me.
Even if it's just seeing some of the case law and how it's been interpreted.
So why don't you start and do not get super nitpicky on reading it. Just give them an overview of each section. But I want to keep this to a shorter
the first document here, this was your response to the show cause order. Basically, your response telling the court why they should not sanction you and prevent you from filing in the future. And the very first thing, most notably, is their little form letter to you was specifically for, a criminal case. So it literally shows they're just not even paying attention to what they're doing. And
what I'd like you to read, or I can read it, is the important dates. Like, just go through all of that. Read that.
Okay. Section 2 here, each appeal arose from distinct, separately entered order. That's key. Everything was separately entered. It's not like it was one order and you've just appealed. These are all
different situations, different scenarios.
Circuit 7 kept issuing orders. You had even asked them to stop while the appeals were going on, and then they denied that stay.
I literally filed several motions to stay. And they just kept doing whatever the hell they wanted because they make their own rules and they play their own game.
The court's order implies a pattern of repetitive successive filing. The actual record of the 4 consolidated case numbers tells a different story. Each appeal arose from a different trial court order, entered on a different date, addressing a different subject matter, and filed only after the appellant exhausted the required lower tribunal remedy. First date, on February 19th. Florida 5th District Court of Appeal consolidated these 4 cases. Exactly 2 weeks later, on March 5th, Florida 5th District Court of Appeal affirmed without written opinion. These 4 consolidated cases, exactly 24 hours later, March 6, 2026, this same court has now filed an order which this response is addressing. This time frame raises genuine concern that the 4 appeals were not individually reviewed on their merits before being affirmed and before the show cause order was issued. Respondent Justin Serlick filed no response to any of the appellate filings.
It's like he does not exist.
And presented no argument disputing the factual basis, jurisdictional issues, or legal authorities raised therein. While absence of response does not itself require relief, so he's not required to respond, and the court can't just automatically grant what you want just because he doesn't.
It doesn't look good that he's not.
So even though doesn't require relief, it does matter. The filings were never substantially rebutted by the opposing party. Under these circumstances, the record shows no support a characterization that the filings were factually frivolous or facially frivolous, knowingly false, or obviously foreclosed by controlling law, particularly when no opposing submission identified any specific established bad faith or abuse.
Yeah. And then after that, there's
sort of just go through each of the 4 cases.
Yeah, there's subsections of the details of each individual notice of appeal. We're not going to go through all of it because it's a lot, but again, you are more than welcome to look through it.
I want to read this part though too. So Section 3, appellant has not engaged in abusive appellate conduct. Appellant is a Florida public school teacher, mother of 4 children. She did not choose pro se litigation voluntarily or frivolously. She previously retained counsel in both Illinois and Florida. Only after years of protracted multi-state litigation exhausted her financial resources entirely, she was forced to represent herself as of October 2024.
There's the RICO.
After her attorney, Rick Brown, randomly withdrew from her case. Appellant has proceeded pro se as permitted by Section 454.18 of Florida statutes, which provides that a person may conduct his or her own case or his or her own cause in any court of this state, subject to the lawful rules and discipline of that court. Appellant does not contend that pro se status is an excuses compliance with the Florida rules of appellate procedure or limits this court's authority to address improper filings. Appellant submits only that any restriction considered here should be based on the correct procedural and factual framework and the actual appellate history of the family law matter, because the proposed restriction would affect the appellant's future ability to seek review.
Which is what they want. They want to silence me, so I'll stop fighting for my children. Nope, we're just getting started, everyone. We're warming up. We're stretching our legs and arms.
This family matter originated in Illinois in 2020, proceeded before multiple judges across 2 states over more than 5 years, and has remained active in Florida for multiple circuit judges and quasi-judicial officers. So even just here in Florida, you're now on the 3rd assigned judge to the case, plus you've had a child support hearing officer and a general magistrate.
Yep.
all dipping their fingers into
a
this.
panel of 3 judges in appellate court directly across the street, all covering for each other.
So appellants' appellate filings must be understood against the unusually prolonged and complex procedural history, not viewed in isolation. Most significantly, despite this more than 6 years of underlying litigation across 2 states, appellant filed no appeals whatsoever until 2025. A litigant who exhausted all available lower court tribunal remedies across 6 years before turning to the appellate court is not the profile of a litigant engaging in systematic abuse of appellate processes. This last one I'll end here, but the Spencer restrictions are designed to address reflexive, repetitive filers, not a parent who appealed for the first time only after years of unsuccessful trial court proceedings. I mean, the reality is,
basically,
you
these
are
judges,
a parent and you are fighting with every bone in your body.
These judges are telling me, stop fighting for your kids. We're not gonna let you. Just stop. Just go away. Just be gone with you. We're not going to allow you to fight for your children.
It is judicial ignorance.
It is abuse of power. And it is crimes against humanity. And it is cruel and unusual. And I will see all of you in federal court this year.
It's pure torture for the families that are getting dragged through the family court system.
Yeah, while they
like this,
they
with
sit in their
$1
million
path forward.
houses collecting taxpayer money.
There's no path forward,
guys. You are paying these people to harm us. All right, so
more positive stuff,
moving on past that. So then we also have to address the affirmed, right? The affirmed without written opinion. So right after I e-filed that, less than 30 minutes later, I e-filed appellant's motion for rehearing and written opinion. And comes now appellant Heather Louise Bendl, appearing pro se, respectfully moves this court pursuant to Florida Rule of Appellant Procedure 9.330A for rehearing of this court's March 5th, 2026 per curiam affirmances in the above caption cases and for the issuance of a written opinion in each case. In support, appellant states. And then this document is not nearly as long. It's pretty much just procedural, quoting case law and state statutes.
You did throw in the court's face that they were ignorant and stupid with copying and pasting criminal court letters on your order.
They seem to think that citizens are uneducated and stupid and they can just be walked all over and none the wiser.
Well, I mean, that's, the reality is in most cases, most people out there would have gotten that affirmed letter and then followed it up with the order to show cause. And most people out there, parents would have thrown up their hands and
just
walked away.
Just given up. Or, unfortunately, some parents take their life. So this is crimes against humanity. There's nothing else to call it. It is disgusting. So I'm just going to fast forward to conclusion. For the foregoing reasons, appellant respectfully requests that this court, 1, grant rehearing in each of the above captioned cases, 2, issue a written opinion in each case addressing the distinct legal question presented, and 3, in the event the court declines to issue separate opinions in each case, issue a consolidated written opinion addressing the UIFSA registration question presented in case numbers 2188, 2696, which directly implicates this court's own precedent, Tristler versus Tristler.
Yeah, it's always nice when you can throw that literally the 5th District Court of Appeals' own case law right in their face.
Yeah, Florida 5th District, DCA, 2008. So we're literally throwing their own case law right back in their face. So that is it for Florida District 5. In the last 2.5 weeks, they've thrown 4 pages at me, and I have thrown over 30 pages back at them, calling them all out, setting up my Florida Supreme Court extraordinary writs, because that is what's next. I knew this was coming the whole time because I am fully aware of what is happening to my cases with the Serlicks and all these paid elected officials protecting the Serlicks.
And it's what we've seen happening to other people all over the country, too. So.
While my children suffer with a 1.0 GPA, they're being hidden away from society. They've lost everything they used to have as far as extracurriculars, Boy Scouts, Girl Scouts, resident camp, etc. Their whole life has been stolen from them. Their extreme unexcused absences do not paint a good picture of what's happening in their lives. I have absolutely no access to them, and I can just look at their school records, their report cards, and their attendance. And as a public school teacher, I can absolutely say there's something happening to my children, and absolutely none of these people, I'm going to be nice, these people are doing anything about it. So they are aiding the Serlicks in neglecting and abusing my children. And that is one of the counts that's going to be in my federal case, is child abuse and neglect at the hands of all of these people that have the ability to step in and help my children, but are actively turning another way because clearly there is something in it for them. And what that is, whether it's money handed under the table, favors, passing things back and forth on the country club golf course.
Just trying to keep their little profiteering system
buying
alive.
Dinners for each other and drinks, or just protecting their sick, twisted RICO system. Who knows at this point?
Or just because they made a bet with another freaking attorney.
Who knows at this point?
They do that too.
Their behavior and lack of action to protect Florida children, because it's not just my children they are abusing and neglecting, is going to end up in federal court. And I can't wait for this summer when that happens.
So
again,
moving on. Yes.
I'm going to repeat these judges' names one more time because I'm going to make some shorts. Judge Adrian G. Soud, Judge Paige Kilbane, Judge John MacIver, however you say his name, and Clerk Sandra B. Williams, all of Florida District 5 Court of Appeals in Daytona Beach, Florida, directly across the street from the Florida Circuit 7 courthouse, where you can throw a rock and essentially it lands in the other parking lot. You guys are all going to see me in federal court this year. Okay, so moving on to some cool and interesting facts. Mark Ludwig's Legislative Leadership Development Program is getting ready to go to Washington, D.C., March 24th and 25th, more advocating for Title IV-D child support reform. And then we will be going back in June 28th through July 1st. If you want to be involved in Mark Ludwig's leadership development team, please go to stlmarkludwig.com and click on memberships. And then that will take you to the Legislative Leadership Development Program. It is $30 a month. And it is well worth the training and the expertise that you get. I have completed the training, and we have weekly meetings, and now we're gearing up, I think, multiple meetings.
And I'll say this, as a political science major in college, what he is teaching you guys, he's teaching you how to communicate with politicians.
And that's important.
And he's giving you like details that a lot of people wouldn't think about like what you can say to certain politicians that you can't say to other politicians.
Right. Democrats versus Republicans.
And the reality is, when you went back in November, when you went to Washington, D.C. with that group, the pictures that you sent me were amazing. It was impressive.
I had an amazing time.
When you go back, I'm going with you.
Yes. Pete is going to be joining me next time, so I'm super excited for that. We're probably going to stick around a little bit longer to actually explore DC, because I personally have not been there since my 8th grade field trip.
Yeah, I think that's the last time both of us was our 8th grade field trips, because that's just what you do in this country.
Social studies field trip.
If you're in a school east of the Mississippi River, you go to Washington, D.C. for 8th grade.
Yeah. Yeah. I had a blast in 8th grade. I still have my massive poster where I should scan that sometime. But I still have my massive poster with all my fellow peers in 8th grade with Mr. Sexton in front of the National Mall and the Reflection Pond. And I had a blast, and I can't wait to actually explore. November 4th, there was absolutely no downtime. We were there to do a job, and we did that job. No downtime to explore and play.
There's so much in Washington, D.C. to check out.
Smithsonian.
I know in school, we had our 5th grade class went to Washington, D.C. For a couple days, and then 8th grade we went for a couple days and saw different stuff each time. And I mean, it was just really cool.
Yeah.
So
that is explaining his legislative leadership team. He also is, he just published a book. So his new book is called the Parental Alienation Handbook. And that website is parentalalienation.playbook.com. So he has put together over the years parental alienation memes that he's always shared on social media. And he decided to combine it all together into a book. Right now, you do have the opportunity to purchase, which I did, for $75, the hardcover, and it is personally signed by Mark Ludwig. So I ordered that one. That is a special edition that is going to be helping fund these DC Title IV-D reform trips. So obviously, I'm a supporter of Mark and everything he's doing and we are doing, and I wanted to contribute to that some more. I also paid to have all 4 of my children's names, Ariana, Tommy, Bianca, and Charlie Serlick's names under the dedication page. So all 4 of my children will be listed in that. And Ariana, Tommy, Bianca, and Charlie, someday I hope you read this book and you recognize some of the abuses that are happening to you by Justin, Mary, and Ira Serlick. They are absolutely alienating you. It is called parental alienation, where they make you hate the other parent, and that would be me. They are spreading a ton of lies and deceit to you and making you hate me when all of that couldn't be further from the truth. I have been fighting to see and speak to you since you were kidnapped.
It is disgusting. And we literally have an email from your ex-mother-in-law where she explicitly states she's making it her goal in life to make sure your kids hate you.
Mm-hmm. Yep. So Ariana, Tommy, Bianca, and Charlie Serlick, you are mentioned in Mark Ludwig's Parental Alienation Handbook, and someday I hope you recognize some of what he has written in there as what has been happening to you all these years by the Serlicks, and why I fought so hard to protect you from the 3 of them. All right, moving on. Some exciting developments, pun intended.
This is pretty cool.
So I have mentioned these 2 attorneys from Louisville, Kentucky multiple times now. I have literally listened to every single one of their podcast episodes. I started listening to the most current and then literally backtracked to the very beginning. So I have listened to every single episode at this point. And their podcast is called the Judgmental Podcast, where you're judging judges. And they are kind of what Pete and I are doing in my podcast, Justice for the Serlick Children. They are exposing what Louisville, Kentucky judges are doing to families and children. So absolutely listen to their podcast. It is great to hear these stories come from an attorney's mouth, not 1, but 2 attorneys that have lived this.
And they make it's listenable. It is not dry attorney speak.
Right. It's broken down in layman's terms.
They are not holding anything back.
No, Christine definitely does not hold anything back.
Putting it out there when they see something that's not right, they are making sure it is known.
Yeah. So attorney Christine Miller and Hugh Barrow of the Judgmental Podcast have been working on a nationwide app where you can judge the judges. It is available to pre-order now on Apple Play Store and will be launching on Google Play Friday, March 13th of 2026. So this Friday.
Got the promo screenshots of it up on the screen so you can sort of see what it does. But it's pretty cool. You can just search and review judges. They have literally put in thousands of judges profiles from across the country. How they did it, how they got everybody, I don't know.
Oh, well, so Hugh kind of explains it in one of the very most recent podcast episodes where he was like, I think it was Alabama, where he was like, you guys in Alabama, you got to do something. None of the judges are on the website, and there should always be a place to find all the judges easily. Yeah. They are public sector employees. They work for the public. Yeah. They're paid by the taxpayers' money.
You don't get to live a life in secret. If you're going to be a judge deciding on other people's lives, the world is going to know who you are.
So he said, in that episode, he said that some states were absolutely easy to find every single judge. Other states were almost impossible to find. So definitely listen to their podcast episodes, because up until this past week, they've been talking about it, hyping it up, but now it's ready to go live. And I am super excited as a techie nerd. I am super excited to play with this app and share it with the masses and get these reviews up. If they're going to judge us, and treat us like subpar humans, then now it's our turn to judge them. How they treat us, how they treat our children, how they rule, and how they don't do their job. It's very clear that these three judges of mine haven't read any of my 4 appeals.
I mean, some of it, you can understand where the idea for this app that they created came from. When you listen to their podcast, they literally have a thing that they do on their podcast. They go to the local courthouse at different times, unannounced,
in court watch,
but midday, business hours. And they go to check and see which judges are actually at work.
Yeah.
And there are times when they'll go there and there will be entire floors of the courthouse just vacant.
There was an episode where Christine was down here in Florida, and I forget exactly where in Florida she was. I feel like it was on the West Coast.
I think it was Hillsborough.
Yeah,
Tampa area.
Yeah, I'm pretty sure it was on the West Coast side of Florida. We're on the East Coast side. But she literally was in that courthouse for most of the day, and it was like a ghost town. There were no judges in the courtrooms, nothing. She even caught one of the sheriffs or security guards sleeping on the job. So It really is a joke. And that's why we, the people, need to start actually talking about this, raising awareness to this, because they are literally stealing our tax money while not doing their job. Yeah. How would people feel if I was paid my $50K salary as a public school teacher and then I just sat at my desk playing on my phone all day or snoozing while my students are just sitting there not learning marine biology? How would you feel as a taxpayer? Even if you don't have children, your money is still paying for the school district. So how would you feel if your taxes are going to public school teachers that literally just don't even come to work but continue to collect a paycheck? It doesn't work. So why are judges allowed to do it? And they're not making $50K. They're making $150 to $200K, if not more. That is a disgrace. They are a disgrace to public sector employees. Complete disgrace. And that is why I am running in the Florida 2026 general election for Florida District 30 House Rep. Because as a House Rep, I can actually do something about these disgraceful judges. I can quite literally put in articles of impeachment in Tallahassee, and then the House Reps have to vote on it. And then if it succeeds with the House, it goes to Senate, and then they have to vote on it, and then we can get the judges out that way.
But at the very least, it is going to put the bad judges' names. It's going to make them more
Tallahassee.
Public. It's going to make them more public.
I'm not afraid of anyone at this point. You've already taken my whole life from me. You've stolen my children from me. You've stolen my life from me. You've stolen my livelihood. I cannot support myself on my own on $1,500 a month. I make a $50K salary, but my take-home pay is $1,500 after the 60% that Justin Serlick is stealing through all of this illegal activity that mommy and daddy are connected with to protect and hide him and my children behind. So Ariana, Tommy, Bianca, and Charlie Serlick of Daytona, Florida, I will continue to fight for you. I will continue to fight for justice for the 5 of us, thus the nonprofit, Justice for the Serlick Children. District 5 can try to silence me all they want. I'm just getting started. There's Florida Supreme Court. There's Illinois Supreme Court. If Illinois District 2 Court of Appeals doesn't do what they're supposed to do.
U.S. Federal Court.
I still have Illinois Supreme Court. And then, of course, there is federal court, U.S. District Court. And I would be starting at the bottom rung. So that means that I can work my way up to U.S. Supreme Court if I have to in Washington, D.C.
You really have to ask yourself, if Justin ever sees this, or what he's thinking, how long does he want to be dragged into court? Because that's what's going to happen.
Obviously, he wants to see and hear my voice.
You're going to go through every single level.
Yeah. So. I'm not stopping until my dying breath. You're going to have to kill me. You're going to have to kill me. I am not stopping fighting for my children. They need help. I have been begging for almost a year now. March 21st of 2025 is when I started this podcast, and I went incredibly public with what this system has done to my children and I, and nothing has been done. And this is literally proving my point that this system is beyond broken, beyond repair. It needs to be burned to the ground and built from ashes up. There is no reforming family court. There's none.
There really isn't.
We have to start all over again with something different, with something better. Yeah. Our children deserve better. Our children's children deserve better. So. Everyone deserves better.
And with that, we want to thank everybody for watching. Anybody that watches the live, we do appreciate your support. I know there were several comments. Tom, you were very active with the comments tonight.
They are corrupt here in Wichita, Kansas. Yeah. Yep. I know Kansas has got issues.
Did they go into your bank account? Not directly, but
they're just stealing my salary as a public school teacher.
Issues with the IRS, the way it happens to a lot of people. But we deal with it.
So the appellate can label a frivolous litigant also. So
yeah, but there. I think he meant the appellee, or just the opposing party.
Well, I am the appellant. Yeah. So appellate court is the actual appeals court. Appellant is me. Appellee is Justin Serlick. Yeah. So I'm not sure exactly what you were asking with that, but yeah, they basically can do whatever they want because they don't follow the state Supreme Court laws or the federal laws. They just make up their own rules to the game. So think cheating at Monopoly. That's what they're doing.
All right. Anybody watching this on YouTube afterwards, please like and subscribe. We're trying to build up that YouTube channel base.
We're trying to get the knowledge out there.
Share the videos.
Yes.
If you're on different communities, even if you have local communities across the country related to family court, if you come across one of our videos here, share it. There's information that it may not help you, but it may help somebody else, and that's what's important.
Yep.
So I'm Pete Arnold.
Heather Bendl.
Thank you, and have a good night.
Good night, everyone.
We want to make something very clear. We are not attorneys. Nothing in this episode should be taken as legal advice. The information we are sharing is based on publicly available records, court filings, and our own personal experiences and research. This podcast is for educational and advocacy purposes only. If you are facing a legal situation or have questions about your own case, we strongly encourage you to consult with a qualified attorney who is licensed to practice law in your state. Again, we are not offering legal advice, we are not practicing law, and the content is not a substitute for professional legal counsel.
They bury the truth, they cut the support. Corruption thrives where the silence stays. But we're lighting the fire to burn down the maze. We are the voice. Justice for the Serlick Children podcast.